Hello, everyone. My name is Matt Hill. I'm an attorney with the Public Justice Center. I'm going to get my PowerPoint up here. There we go. So I'm going to talk a little bit about renters' rights and housing, using a lot of the questions that we hear a lot. As the Public Justice Center, we provide legal representation and advice to tenants throughout Maryland, primarily in Baltimore City, on housing and eviction related issues. So the biggest question is, when will evictions start again? And there's kind of a complicated timeline, and there'll be some exceptions in here later. But essentially, if there's an emergency, what they're calling an emergency breach of lease or wrongful detainer case, that could be heard now. What does it mean to be an emergency? There has to be some sort of threat to the tenant's conduct. Essentially has to be causing some sort of threat to the life, health, and safety of the landlord or other occupants. So we're not going to hopefully see many of those. On July 20th, we'll see rent escrow actions starting again. So I know we get a lot of folks who have all sorts of really awful conditions that the landlords have refused to fix. And so you can file, even now, a complaint for rent escrow. It won't be heard, however, until at the earliest July 20th. Now, July 25th is really when evictions start up again, according to the court's current order. So if there was an existing eviction judgment or warrant prior to March 17th, when eviction stopped, that could be executed on or after July 25th. You may get notice of that date. You may not. We're still trying to work with the sheriff's office and find out what their plan is to move forward on that. Tenant holding over cases and breach of lease cases can move forward starting July 25th. Tenant holding over may be applicable to a lot of folks. We've seen a real uptick in tenants who tell their landlords, hey, I can't pay the rent because of I've lost my job because of COVID-19. And landlords are becoming increasingly aggressive, saying, no, you need to pay me the rent now, as well as they send the tenant a 60-day notice to terminate their month-to-month lease, or they refuse to renew the one-year lease. And if you, hypothetically, if you stay over past that 60-day notice period and you don't have another defense, then the landlord can file a action for tenant holding over. Now, there may be some defenses to that action, and you want to consult with an attorney to talk about your defenses a little bit more, but we expect to see more of those tenant holding over cases. Foreclosures and tax sale foreclosures can also start again on July 25th. New failure to pay rent cases. This is going to be the bulk of the cases. So cases that have been filed for failure to pay rent, that are going to be filed. The court will start to hear those again on August 31st. And so we expect a lot of evictions to be filed in July, after July 25th, to be heard after July 25th, but even more on or after August 31st. You should check with the court's website. There's a link there because these things are always changing. And so whatever I tell you today, frankly, could change tomorrow. So please do check with the court's website there. If you can't pay your rent due to COVID-19, again, landlords can file the eviction cases, but it's not going to be heard until the time frame that I just laid out, depending on the type of case. Now, the governor has issued an executive order. He claims it's an eviction moratorium on all evictions. That's just not true. So his order, all it says is the tenants may have a defense related to a COVID-19 loss of income or health issue in certain types of evictions, mostly failure to pay rents. That still is in effect. So if you hypothetically, if that's still in effect in September and you can prove you've had a COVID-19 income loss, that might be a good defense for you. However, the governor could withdraw that order at any time. So we definitely don't want to depend on that. You want to communicate and negotiate with your landlord. Get any agreement in writing. So don't just rely on your verbal discussion with the landlord on the phone, because I'm telling you what's going to happen is there's going to be some sort of misunderstanding, and unless it's in writing and your landlord goes into court and says, hey, this person didn't pay the rent, you can say we had a payment plan, but unless it's in writing, it's going to be very difficult to enforce in the court. Is there financial assistance available? There's not a whole lot right now. You can call 211 now or at any time, and they have probably the best list of what is available and not available. Baltimore City is going to start announcing a plan for rental assistance. It should open, I'm told, by July 1st. You want to get in line as soon as possible. So there will be an announcement. We're going to put it on our website. We're going to broadcast it as wide as we can. But starting July 1st, tenants will be able to apply for rental assistance, and there will be some sort of, there will be different criteria, but it is important to get your application in as soon as possible. So be on the lookout for that. What if the landlord changes the locks or shuts off your electricity? That's illegal. So any eviction, any denial of essential services without the sheriff present is illegal. So if the landlord's trying to do that, they're in the middle of trying to do that, you call 911. If you have been evicted or utilities have been shut off and you want to get back into the house, you need to try to file an emergency complaint with the court. You also want to keep track of any expenses or lost property. This is a criminal matter in Baltimore City, so you can also go to the district court commissioner and swear out a criminal complaint and bring some real pressure on the landlord. Hey, let me back in, or you're going to be going to jail. And sometimes that is successful. And then just to be clear on utilities, the governor's extended the utility shut off to July 1st. But after July 1st, utilities can be shut off unless that's extended. I don't know if that's going to be extended or not. So what happens when the eviction pause is lifted? So if you haven't had your case yet, you're going to get a new trial date from the court. Again, because some of your defenses depend on your loss of income, or maybe you had some agreement with the landlord. You want to keep all those communications and all that documentation about loss of income close at hand. And if there's an existing eviction order or warrant, again, we're not sure whether you're going to get new notice of the eviction date. If you've never gotten notice of an eviction date before, then yes, you're going to get notice. The question is, if you got notice of an eviction date, let's say it was supposed to happen on March 16th or March 17th, and it got canceled, are you going to get a new notice after July 25th? And that's something we just don't know about yet. If you're living in subsidized housing, you have a Section 8 voucher, you're living in public housing, some other deep subsidy that depends on your income, and you've lost income, landlord as soon as possible about that income. If you need to report that income to the Section 8, to the housing authority, then you want to do that as soon as possible. When you don't report that income, or there's a delay in your reporting, it can affect how much rent you have to pay. Landlords should be taking steps to avoid the spread of COVID-19. They should be putting limits on visitors. They should be closing common areas, or limiting gatherings and doing extra cleanings. They aren't all doing this, but they definitely should be. Having said that, they can't stop you from getting essential services in your home, like a nursing aid or meal delivery or a cleaning service. So you need to be assertive with your landlord about that. And if you're having difficulties, you can always give us a call. So there are some federal protections that are available to certain folks in federally subsidized properties. So there's properties where you've got a voucher, where it's some sort of tax credit property. It also applies, though, in the properties where there's a mortgage that's backed by Fannie, Freddie, or the FHA. The problem is you probably don't know whether your landlord has a mortgage backed by Fannie, Freddie, or the FHA. Truth is, we don't know most of the time whether the landlord has a mortgage backed by Fannie, Freddie, or FHA. There's some search tools you can use, but they're not comprehensive. So it's very difficult, but we can do some digging and try to figure it out as best we can. And if your property is covered or you have a voucher, the moratorium has been extended on evictions through August 31st. After that, your landlord has to give you a 30-day notice. If your landlord can also qualify for mortgage forbearance, meaning they don't have to pay for a period of time, while they're in forbearance, they cannot file for eviction. They also can't charge you any late fees. So again, if you're trying to figure out whether your landlord's property is covered, you can dig around a little bit online. There's some search tools, and you can just Google, is my landlord covered by the CARES Act, and do a little investigation yourself. But if you're having difficulties, give us a call. There's also a Baltimore City law that protects tenants from certain things, and that is late fees and rent increases. So any late fees or rent increases after March 5th are prohibited for the period of the public health emergency that's still going on. And the exception here is if you're a renter and you're in subsidized housing and your income increases and you report that, then your rent's going to go up because that's under kind of a separate program. Foreclosure, if you're a homeowner, if your landlord's facing foreclosure. And so the federal foreclosure moratorium on those federally backed mortgages has been extended through August 31st as well. So your landlord is telling you, oh, you have to pay me or I'm going to get foreclosed. It'd be nice to know if they have a federally backed mortgage. I've seen different statistics on this, but between 50, 70% of single family units have federally backed mortgages. And so they may not actually be facing imminent foreclosure despite what they may tell you. Again, they can also get forbearance if they have those federally assisted mortgages. So that's something you want to make sure that if you're a homeowner or you're a landlord that you know about, and it's helpful for tenants too. This is a list of contact information for all of us who are presenting and some resources. I think we went a little out of order with the presentation, so we can move now to Sally, and maybe later we can put up this sort of resources and contact information slide. So thank you.
Awesome. Thank you, Matt. I just want to remind everybody that maybe somebody needs to be muted. Okay, that's much better. Awesome. I just want to remind everybody that during the presentations, you can add questions in the chat. I forgot to say that at the beginning. And then we're going to go through them towards the end. Yeah. So with that, we're going to go to Sunny and his presentation on some of the worker stuff.
Hi, everyone. My name is Sunny Desai. I'm an attorney with Maryland Legal Aid in Baltimore City. We cover the entire state of Maryland. So if you know anybody outside of Baltimore City that could be helped, please have them contact Maryland Legal Aid. I'm going to start by sharing my screen here. Okay. And please let me know if you can't hear me if I'm a little bit low. I'm going to try to speak up. Okay, so we're going to talk about unemployment law, especially what to do, how to decide whether you should return to work or whether the conditions are unsafe and what your options are with unemployment law. Okay, so I'll just briefly go through regular unemployment. I did a Know Your Rights training about a month ago that should be on the Facebook page. I believe it's on YouTube. So if you want more details about unemployment law, please go watch that. But just quickly, what I'm calling regular unemployment is basically pre-COVID unemployment. That program was designed to get folks back to work as soon as possible. And of course, now we're trying to keep folks home as much as possible and stay socially distanced. So regular unemployment is for employees who lost their jobs through no fault of their own. So layoffs is a typical example of that. But there are some requirements in addition to that to be eligible. So for regular unemployment, you have to have worked under covered employment. Basically, that means you receive regular pay stubs and W-2s. You also had to have worked in the last 18 months. You have to have a steady work history. Also, you have to be able and available. You cannot be disabled. You have to actively look for work and be available in the customary hours that your occupation requires. You also can't be discharged for unemployment. So if you're fired for misconduct, you may get a penalty or may be disqualified entirely. And once you file for unemployment, that's not the end of the story. Of course, you have to file weekly certifications, report any earned income that you may have gotten from a part-time job, for example. And also, typically, you have to have made at least 3 job contacts. That job contact requirement is currently suspended, but it will resume at some point when the health crisis is over. And then finally, what we're mostly here to discuss is, used to be that you had to accept suitable employment. If the job where you were laid off from wanted you back, typically you had to take that job. Otherwise, you would be disqualified from receiving unemployment. So let's talk about some of the changes. So these occurred mid-March, just about. So for Maryland specifically, unemployment benefits are now available if your employer temporarily shuts down because for a governor's order, for example, or the employee has to quarantine, or the employee leaves the job because they risk getting infected by COVID-19, or they leave because they have to take care of a family member. And if your grandmother or grandfather used to attend adult daycare during the day, but now can't because the daycare is closed, then you would have to stop working so you can take care of them. And there was the requirement that you need to quit or be fired was eliminated temporarily. And of course, if you needed to quarantine, the employer cannot terminate you. Your job was protected while you were under quarantine. It's still protected. So that was the changes in Maryland law. Now I'll go over some of the changes under federal law. The first change is if you're eligible for even $1 in unemployment benefits, the federal government is adding another $600 on top of that, no questions asked. That expires at the end of July, and there's some talk of extending that, but that hasn't passed. That law has not passed yet. They also extended the number of weeks you can get the benefit. So in Maryland, typically you only get 26 weeks of unemployment benefits in a given year, but under the CARES Act, they extended that by an additional 13 weeks. So now you're eligible for 39 weeks of benefit. And then finally, the biggest expansion for unemployment law was PUA, or Pandemic Unemployment Assistance. All those requirements that I mentioned for regular unemployment, a lot of those don't apply to PUA. So for example, if you're self-employed, you are not eligible for regular UI, but you are eligible for PUA. Same thing for independent contractors or folks who haven't worked steadily for the last 18 months. Or if you even have a penalty on your record from a previous unemployment case from last year, for example, you would not be eligible potentially for regular UI, but you will be eligible for PUA. The additional requirement is that the unemployment has to be a result of COVID-19. So the employer shut down or closed the business because of COVID-19. You have to take care of a family member because of COVID-19. There's a list of reasons. This benefit is also available for 39 weeks. In Maryland, the minimum benefit is $176 per week, plus the $600, of course, that I mentioned, through July 31st. If you receive paid leave, however, you're not eligible while you're getting the paid leave. Undocumented workers also, unfortunately, do not qualify. Okay, so now let's talk about return to work. Let's say your employer opens back up, you're called back into work, you go to work, you realize that the employer isn't really, while they're saying they want to follow CDC rules, that's not actually happening in practice. So you decide that it's not safe to work here. You talk to your boss and you say, I'm going to go back home. I'm not going to show up to work because it's not safe. You're not taking the precautions necessary. So what happens in that case to your unemployment benefits? Well, typically, unemployment insurance is not available if an individual voluntarily quits. They just don't want to work at that job anymore. you're typically not eligible unless you have good cause or valid circumstances. So examples of good cause include your boss is just not paying you, or it's a hostile work environment, the boss is verbally abusive, or the boss is asking you to be unethical or skimming money, etc. That would be good cause. You're not required to break the law. So that would be considered good cause. Valid circumstances would be health reasons. So you have to go take care of somebody who's suffered an illness, or you need to take care of a family member. And the reason that's most relevant for us is it's not suitable employment. I'll talk a little bit more about what suitable employment means. And a lot of this area is new. We've never gone through a pandemic really before, so it's an unsettled area of law, but I'm sure we'll be litigating a lot of these cases. Okay, another scenario is your boss calls you back into work, but you know that the CDC guidelines are not being followed, for example. So you refuse to even go back to work. You don't even show up. So again, typically unemployment insurance is not available if you refuse to return to work, unless there's good cause or the work is unsuitable. So good cause is, in this circumstance, is a case-by-case determination. Obviously, if you're diagnosed with COVID-19, I think you would have good cause, but it's unclear. I would argue for my clients that if my client is a higher risk for severe COVID-19 related illness, that should count as good cause. Or if they live with somebody who's at a higher risk. And finally, if the employer is not following CDC guidelines and not giving you an option to telework, it's just clear no one's wearing a mask, nothing's getting wiped down, things like that, I would argue that's good cause to refuse to return to work. But that's, like I said, unsettled law. That'll have to be litigated on a case-by-case basis. We are trying to get the Department of Labor, Maryland Department of Labor, to issue some guidelines, some stricter, some clear guidelines, but that hasn't happened yet. Also, another argument might be that the employee refused to return to work because the work just wasn't suitable. It involved risks to the employee's health, morals, and safety. And then the other three reasons are really not relevant for a COVID-19 situation, but you can also refuse to return to suitable work if the new job, not your old job, but a new job pays less than what you used to earn. It's not in your usual occupation, and if the commute is too long, if you're required to travel too far, in certain cases you can refuse to return to work. But really, the main argument for our current discussion is that if it's harmful to your health, you shouldn't have to choose between making a living and your health. Okay, so one disclaimer is refusing to return to work just because you have a general fear of being infected is likely not good cause. So if you're just nervous, anxious, understandably so, but for unemployment purposes, you have to have some kind of a specific, reasonable, articulable. You have to be able to say, my employer is not following guidelines. I am immunocompromised. If I get COVID-19, I could potentially get severely ill, and that's why, something specific like that. I'll briefly mention the unemployment process. So you file an application, you might get a telephone interview. The interviewer talks to you and your employer, and then they produce a fact-finding report that might result in a denial. You have to file an appeal within 15 days. Right now, I suggest putting your appeal through mail, just because Department of Labor is still working. A lot of folks are working from home still. There's also an email address that you can email it to, and that's on their website, which I'll share in the next slide. So I would do both, mail and email. You can fax it as well, but a lot of people obviously don't have access to the fax machine. And then finally, once you file an appeal, telephone hearings right now are being scheduled 4 to 6 weeks out. and you have a right to an attorney at that hearing. So if you call Maryland Legal Aid, we might be able to represent you at that hearing, especially if it's an issue related to returning to work. So just be mindful of that. The sooner you can call us, the better we can prepare for your hearing. And then finally, the penalty, if it is found that you voluntarily quit or you did not return to suitable work without good cause, the penalty is you have to earn 5 to 10 times your weekly benefit amount before you can be eligible again to file for unemployment. So it's somewhat of a steep penalty. So it's worth litigating this issue. And here are just some links. I'll leave it up for a bit, and then we'll share the presentation, of course. The first link is to Department of Labor's unemployment website. But if you want to file a charge for employment discrimination, if the employer isn't following CDC guidelines that they terminate you for some reason, that might be discrimination. So you can file a complaint with EEOC, with MOSH, which is the state agency that does the same thing. Also, after that, I've put up 2 publications that OSHA and CDC published about what businesses should do to prepare for employees returning, to protect them from COVID-19. And then finally, I put up Legal Aid's link to COVID resources, not just unemployment, but we do housing and all other family law, all kinds of different areas of law. So please give us a call. Our intake line is at the bottom there, 410-951-7750. And that's everything I had. And my email address is there as well. If you have a quick question and want to send me an email, please feel free to do so.
Awesome. That was great. Thank you, Sunny. So now, if Sally is ready, she looks kind of wonderful. She can share her screen and go on with her presentation.
I am. Can everyone hear me? Am I coming through? Okay. I've had some internet difficulties throughout the presentation, so relying on Amanda and others to let me know if I'm not coming through clearly. So thank you, everyone. What I'm going to talk about for the next few minutes are both new rights that folks have to paid sick leave in the era of COVID, Maryland's state law when it comes to paid sick leave, and some of the limitations to be aware of in each of those. All right, so diving right in. You know, Congress passed what's called the Federal Families First Coronavirus Relief Act, otherwise known as FCRA. This is the first time, actually, while it is not what we had hoped for, it's the first time that Congress has actually recognized a right to paid sick leave. And, you know, as Sunny pointed out, folks shouldn't have to choose between making a living and their health. So this is the first time we've had recognition of the need for a paid sick leave law. So what does this do for you? It will provide 10 paid sick days, paid leave to full-time employees, and part-time employees will have paid leave for the hours that they typically work over a 2-week period. It's immediately available in addition to any other paid leave that you might have on the job. Now, the downsides are that this law was passed only for purposes of COVID, and it will sunset at the end of the year. There are many efforts going on to extend it, but for now, it sunsets on December 31st, 2020. Now, what are some of the limitations? So, interestingly, the law does not apply to big businesses, or perhaps not interestingly. It doesn't apply to employers who have more than 500 employees. So bigger businesses that we hear about in the news do not actually have to provide this benefit. Some businesses, which I'll explain later, with fewer than 50 employees will also be exempt. It also doesn't apply to healthcare providers and first responders. And unfortunately, the Department of Labor has issued guidance suggesting that companies that contract with healthcare providers and first responders can also exempt their workers. Finally, it doesn't apply to any leave that was needed before April 1st, or if a business went out of business, if a business closed up shop in March, you couldn't get paid sick leave for prior to that time. All right, so what are the reasons why you could take sick leave, assuming you work for an employer of the right size? You can take sick leave if you're subject to a quarantine or an isolation order related to COVID. If you've been told by a healthcare provider that you need to self-quarantine or you have concerns related to COVID. If you're experiencing symptoms and you're seeking a diagnosis, or if you're caring for another individual who has been either diagnosed or is subject to the quarantine order. Additionally, you can also get paid leave if your son or daughter's school or place of care, like the child care center, has been closed due to COVID precautions. Now, I have an asterisk on number 5. That's because for that basis, if for those that are caring for a son or daughter where the child care center has been shut down, employers that have fewer than 50 employees, they can seek an exemption. They have to attest that granting the paid sick leave would cause them substantial harm, and they can exempt themselves. So where you're talking about needing paid leave because the daycare has been shut down or the school is shut down, if the business has fewer than 50 employees, just know that they may seek an exemption. You'd have to check whether they actually have. Not all of them have. So, and then finally, the sort of catch-all is any other substantially similar condition as determined by the Secretary of Health and Human Services. So far, there haven't been statements that what constitutes a substantially similar condition. So that's sort of on a case-by-case basis. But those top 5 COVID-related reasons are reasons to seek 10 paid sick days. Now, how much will you get paid? So the law, can folks hear me? Okay. All right, so the law says that you will get your full regular hourly wage. Now, that means if you make $15 an hour, you'll get the $15 an hour for every hour of paid leave you take. There's a cap up to $511 a day. You get that full rate of pay if you're taking leave either to get a diagnosis because you're symptomatic, because you have to quarantine, or because you're complying with some sort of isolation order, even if the business is still open. You don't get your full rate of pay, however, you'll just get 2/3 your rate of pay if you're caring for another individual. So when it comes to paid leave for yourself, you get your full rate of pay. If you're taking care of another or a child where the daycare or school is closed, you get 2/3 of your regular rate of pay. Okay. Some additional things to know about with regard to the federal sick leave is that it doesn't matter if you just got hired 2 weeks ago, it's available for immediate use. The way that it works for the employer is that the employer can submit, the employer basically gets reimbursed with tax refunds for any amount of sick leave that they're giving through this law. So you don't have to have, unlike other laws, you don't have to have worked there for a certain amount of time and earned the leave. It's available immediately. You're also able to take this time prior to using any existing paid leave that you might have. The law clearly says that you can use this as a first resort and then tap into anything that may be available. Your boss can't require you to search or find a replacement. You know, if you're told, like, I'd love to give you the paid leave, but who's going to work your shift? That's inappropriate and prohibited. As Sunny mentioned, I believe you cannot both be taking your 10 days paid sick leave under this law and getting unemployment insurance. So there's no sort of you get one or the other, but not both. The law does contain some protections for folks making claims. The business is prohibited from retaliating, discharging, demoting anyone who takes the leave or asks to take the leave. All the businesses should be providing notification to their employees of this new benefit. The Department of Labor will accept complaints of violations. You can also call the Public Justice Center, and we can help you with an intake to find out whether we can further assist. All right, so in addition to federal paid sick leave, Congress also extended certain provisions of the Family Medical Leave Act and in response to COVID. Now these are specific, they're not like your usual Family Medical Leave Act provisions. These are specifically related to COVID and specifically related to the need to take care of children because of school and daycare closures. So in addition to the 10 days paid paid sick leave that you can get, employees are eligible for an additional 10 weeks of COVID paid leave if they can't work, assuming you can't telework. If you can't work because your minor child's school or daycare has been closed, or the child care provider is unavailable because of coronavirus. So again, this is 10 weeks of paid leave, but again, because it's leave that you're taking to care for another rather than yourself, it's paid at 2/3 of the regular hourly rate. So it's not your full pay for 10 weeks, it's 2/3 of that pay. Okay. And for extended family leave, unlike paid sick leave, you must have been employed for at least 30 calendar days before you take that leave. And again, this only applies to employers that have fewer than 500 employees. So the big employers are off the hook on this one. And like the other federal sick leave law, it generally does not cover the folks who probably need it the most, like healthcare providers and emergency responders. Again, as I explained earlier, if it's a smaller business with fewer than 50 employees, if they can show that sick leave, giving this extended leave or sick leave would jeopardize their ability to remain open, they can basically say that they can't provide it. Okay, so as some of you may know, federal sick leave is not the only sick leave that workers have available. Maryland has its own sick leave law. It's called the Healthy Working Families Act. It's a state law. It's not related to COVID-19, and it does not expire at the end of this year. It also covers those big businesses that the federal law does not cover. That said, it's not specifically COVID related, and it was generally designed to deal with shorter term illnesses and domestic violence and stalking. I'm going to go through some of the provisions of that law as well, just so you know what is out there. I do want to add, though, that this law is a law that can and should be stronger, and we would love to hear from folks with experiences trying to take leave under this law. We would love to advance a broader, stronger, Healthy Working Families Act. So if you have experience, some of the limitations I want to be clear about. As I said, there are no specific protections for public health emergencies like COVID. There should be, but there aren't. The law also exempts many of the workers who do essential work during COVID, such as agricultural workers, temporary workers, on-call health workers. It also exempts seasonal workers in tourism and retail. So, Not everyone is covered under our Maryland state law. That's something we would love to fix, but it does cover something like, it does cover the vast majority of the Maryland workforce. So let me tell you a little bit about what it does. For Maryland employers who have 15 or more, 15, not 50, 15 or more employees, those employees, every employee has the right to earn sick leave. They earn 1 hour for every 30 hours the employee works. Employers can also give a lump sum. If they give a lump sum, there's a maximum of 40 hours of leave a year, so you might just get 5 paid sick days at the beginning of the year. The law says that employers don't have to allow you to accrue more than 40 hours. You can carry over hours from year to year. So you can carry over some hours, but you can never have on the books more than 64 hours, which means that you could have up to 8 paid sick days accrued, depending on how long you've worked and accrued. The employers a business can tell you that you have a probation period, or you don't get to use your leave until you've been employed for 106 days. Now, I know 90 days is the normal probation period. 106 days is a bizarre number. It comes from legislative compromise that I won't get into, but just know that the employer can tell you you need to work for 106 days. You need to be employed 106 days before you can use that leave. Also, because leave is carried over, it can also be reinstated. So if you're a seasonal worker and you've left your job in the tourism industry, but you're rehired within 37 weeks, that leave should be reinstated. Employees should also be getting statements of how much leave they have, how much they've used, and how much they've accrued with any pay stub or an online format. Now, as you saw, I said employers with 15 or more employees do paid leave. Smaller employers must still give job protected leave or unpaid leave. Now, obviously that's, that doesn't pay the bills, but at least the job is theoretically protected there. We would love it if we had a sick days law that covered everybody and had paid leave for everyone. So, as I mentioned, the Healthy Working Families Act was designed also to provide for short-term illnesses and domestic violence and stalking issues. So you can take time to care for your own mental or physical illness or injury. You can take time actually to seek preventive care, and you can take time to either care for a family member or obtain preventive care for a family member. And I want to point out that the family member is broadly defined. It's parent, child. It also includes legal guardians, grandparents, grandchildren, and it's not limited to biological relationships. So stepchildren, foster children, all included in the family member. In terms of the domestic violence and stalking, you can take leave to seek services from a survivor services organization to obtain medical or mental health care, or to relocate if the situation is severe enough that that you need to relocate. You can use your paid sick leave for that. Okay, I just want to point out so folks know there are other limitations to this law. With leave that's for preventive care, like a doctor's appointment that you know about, you may have to provide notice. So you just need to know what your employer's policy is. Businesses are also allowed to request verification. In other words, that you use the leave properly after just 2 missed shifts. And there are certain rules around whether leave can be denied. Like if an employer asks you for verification and you don't provide it, then the next time you ask for leave for that same reason, they may deny your leave. In terms of violations of the Maryland law, the complaints generally go to the Maryland Department of Labor. I have the link there. There's a relatively straightforward form to fill out. You can also call the Public Justice Center for questions on that. And then finally, I just have some additional sick leave resources here. On the Public Justice Center's website, we have a COVID page that also has frequently asked questions and fact sheets. Better Balance, which is a national organization, also has similar frequently asked questions and fact sheets. And then finally, there's a Know Your Rights. There are Know Your Rights materials on both our websites and a Better Balance website. So I think that is it for me. So I'm going to stop the sharing and open it up to Beck for questions.
Yeah, that sounds great. I think we have a couple in the chat, and yeah, we'll let Beck do it.
Hi, everyone. So I'll go ahead and start. Can everyone hear me? Okay, I'll go ahead and start with some questions. The first one is just a general question about how and when will this presentation be shared?
That sounds like an Amanda question.
Sorry, I forgot to unmute for a second. And I was thinking about it, but we're gonna send these out, I believe either tomorrow or early next week, Monday, once we have the recording kind of figured out and processed and put on YouTube.
A couple questions for Matt now. The first one is, what kind of late fees will be able to be applied to back rent after the stay on evictions and court cases is over?
Well, there shouldn't be any late fees imposed from March 5th all the way through the end of whenever Governor Hogan says that we're no longer in an emergency. So if a late fee was charged before that, it's still going to stick. But if it's charged after that, and the March 5th piece is interesting because a lot of these late fees get charged March 6th. And so I don't think those should be allowed. And I think essentially any late fee in March or going forward should never be charged.
Great. Another question for you. If a tenant stops paying rent during the moratorium on evictions, will that rent be forgiven once the moratorium is lifted and court cases are being heard again?
Not right this moment. There are some, yeah, we certainly hope so. But, you know, there's a campaign that I know CASA is really involved in around cancel the rent. And that's, you know, still something that I know a lot of folks are really working toward and we support. And then there are also other campaigns to try to provide to get Governor Hogan and the city and other jurisdictions to do more, what do we call emergency rental assistance. So to pay part of that back due rent, or all of it in some cases. And again, that in Baltimore City is going to be becoming available July 1st. So while I would love to say, let's cancel the rent, it's not happening at the moment. And so I really strongly encourage folks to apply for those rental assistance programs.
And is there any talk of programs or resources that will help with utilities? And would that be covered under the new program designed to provide rental assistance?
So there are programs. The best resource, I think, is probably it's called the Maryland Office of People's Counsel, and I'll look up their website in just a minute and put it in the chat. But they usually have the most up-to-date financial resources that are available to folks for utility bills. My understanding, at least of the city's program, is it's only going to cover rent. at the moment.
A couple questions for you, Sunny. Regarding unemployment benefits, is it possible to apply for these benefits and backdate the application if I was unable to apply sooner for COVID-related reasons? And if so, will the amount of weeks that you're eligible for be affected?
Right, so you can backdate your application. The Department of Labor has said, because of COVID-19, they're going to provide you with all benefits you're owed. If you apply now, but your unemployment started in April, you will get all of those weeks. So the number of weeks you're eligible for will still remain at 39 weeks, but the clock starts when you lost your job, right? So it won't be 39 weeks with the date of the application. It'll be 39 weeks starting from when you were unemployed. Yeah, so it shouldn't affect that eligibility. It'll just affect, you'll get a one lump sum payment of back pay that you're owed, and then you'll get weekly benefits of your weekly benefit amount plus $600. That $600 is set to expire end of July.
Another question for you, Sunny. Would a worker who is an American citizen be eligible for unemployment if their most recent job was overseas with an international company, but they had to return to the US due to the pandemic?
I don't believe they would be eligible for regular UI because if you apply for unemployment in Maryland, they look at what Maryland employers have reported to the Department of Labor. If you live in Maryland and you work in Virginia, for example, the state of Maryland is supposed to contact the Department of Labor in Virginia and get your work history from there. But I don't know of any such program for international employment. But at least for this year, you will be eligible for PUA. PUA is kind of like a catch-all. If for whatever reason you're not eligible under the regular UI, you will be eligible under PUA. Most likely, they'll assume that you don't have any work history because they can't find it, and you will get $176 per week, plus the $600 at least through end of July. And then just one more point on that. If you only work in Virginia, but you live in Maryland, so you work out of state, you have to apply for unemployment in the state where you work. And that state's laws apply. So most of unemployment laws are the same from state to state, but there are significant differences. So the presentation I gave today is just on the Maryland laws. I'm not barred in Virginia or in any other state, so I can't tell you exactly what their laws are.
Thanks. And then a couple questions for Sally. Can I use sick leave to take care of my sick kids or family members, or does it only apply if I'm sick?
The state sick leave law applies to take care of, will apply to take care of family members as well. The federal law will apply to take care of family members if it's for COVID related reasons, and that would be at 2/3 your regular hourly rate.
Great. And then another one for you, Sally. For the requirement that the employer posts the new FLSA Rights, is there some guidance about how it can or should be done virtually? And if so, is it phased in such a way that workers would have the right to demand virtual dissemination of these rights to coworkers?
I'm sorry, Beck, I missed, I think my internet went out there. Can you say?
Sure, let me repeat it. For the requirements that the employer has to post the new FLSA Rights, is there some guidance about how and when it should be done virtually? And if so, is it phrased in such a way that workers have the right to demand virtual dissemination of these rights to coworkers?
Yeah, so I believe the statute says employers must give notice. And then there is USDOL guidance that says, but does not, it says the notice should be posted in areas, and then if the employees are teleworking, they should send the notice by email or post it on websites. So there's nothing specific saying you must do it in any particular manner, but I think if employees aren't getting the notice, then that's a violation.
A new question for you, Sunny. Does the opening up of businesses in some states affect any COVID-19 protections? So for example, if someone was working in a restaurant and temporarily lost unemployment, but then received it back, now the restaurant is not allowed to reopen and rehire workers, but the employee doesn't feel safe returning to work. Is there anything that they can do?
Right, so this problem is one that we're expecting as the state continues to reopen. We're going to see this more and more, I think. So as far as unemployment law benefits, if you refuse to return to work, you don't want to go back to the restaurant because the restaurant is not following proper guidelines. They're not keeping you safe. They're not keeping the people who are coming to the restaurant far enough away, all those kinds of things. Then if you refuse to return to work, Department of Labor should keep giving you unemployment benefits. If you get denied, however, because Department of Labor says you were asked to return to your job and you didn't, you can appeal that denial, and we may be able to represent you at that hearing and argue on your behalf that it was unsafe to return. Now, if you just rather stay at home, you want to limit going outside at all as much as possible. You just have a general fear. It's not for any health reason. It's not because you're immunocompromised or someone you live with is immunocompromised. You just have a general fear of going out because it's not safe. That typically will not be enough to continue receiving unemployment benefits. Now that's just the unemployment side of it. There's also an employment law side of it. If you stop going to work, your employer might terminate you. And that raises some employment law questions that there could be possible discrimination there. But I'll let Sally cover employment law questions.
All right. Well, those are all of the questions that we have that were written in the chat. Folks on the phone, if there's a way for you to unmute yourself, if you have a question that you want to ask because you weren't able to put it in the chat, you can go ahead and unmute yourself now if you have a question.
Yes, can I be heard?
Yes, please go ahead.
Hello? Yes,
Go ahead.
my name is Jeanette Snowden, and my question is for Matt. I'm still in public housing, and I was told that I owe some back rent. I'm in agreement with that, but I want to know, is the formula the manager is supposed to use based on what was the gross pay per month or the net pay? The 30% calculations that they do.
Yeah, so the formula for calculating your portion of the rent can be really incredibly and unnecessarily complicated. So I suggest that we assist you, we get you to legal aid if that's possible, because they usually provide most of the advice relating to exactly how the formula should apply in your particular case. Sorry?
Okay, you're not familiar with that question.
I'm not as familiar with that. That's right. So if you can call legal aid at the phone number that Sunny provided on the PowerPoint, I think that's probably best.
Okay. I did have one more question. If the landlord informs you by letter that he is going to sell his property, which you have been renting in, does all he have to give you a 60-day notice and that's it? Is that appropriate?
Yeah, so I can't give out individual advice on your particular case, Ms. Snowden, but if you call us, I'd be happy to do a full intake and we can provide you individual advice. I can say that in general, Generally speaking, your lease survives any sort of sale to another party, right? So if you have a 1-year lease and your landlord sells the property to somebody else in the middle of your lease continues, and they can't just give you a 30 or a 60-day notice to vacate. Now, if you're on a month-to-month, it may be different. Maybe they can. And then also there's a law that applies in many situations where a tenant should have a right to a first right of refusal to purchase the property. So, you know, there are a lot of different situations out there. And so I definitely advise anyone who's interested in that to give us a call. We'll conduct a full intake and be able to provide more specific advice.
All right. Thank you so much.
Thank you.
We do have all participants who are calling in on their phone unmuted right now. So if there's anyone else on the phone who has a question, please feel free to go ahead and ask it now.
Good afternoon. Can you hear me? Well, yes, thank you. I simply wanted Samuel Jordan with the Baltimore Transit Equity Coalition. Good evening to each of you. I'm simply asking if the notes or of the discussion will be distributed following the meeting. Do I give you my email address and can get some of the comments?
Yes, we can get that to you, Mr. Jordan.
Okay, I'll send that to the host, or Matt or Sally, someone else.
You can send it to me, Mr. Jordan, Amanda@unitedworkers.org. Anyone who's joining over phone, please send me your email. That's how we're going to share out the notes, the presentations, the slides, all of the good information that our presenters have shared. So again, it's Amanda@unitedworkers.org, just so I have your email, Mr. Jordan. Of course, yes. I do have yours, but we will make sure that you get that information.
Okay, very good. And thank you so much, Amanda.